Good morning, everyone. We will still wait a few minutes for all the attendees to join. Welcome to our webinar. Good morning. So we will start. I just would like to make sure that you all see the screen. Dunya, you can share your screen. Should I share my screen? Let's wait 2 minutes still for people to join, and in the meantime, we'll present.
Do you hear us?
Yes, we hear you, Dunya.
Okay.
We just don't see screen anymore. We just don't see screen anymore. Can you share your screen? Or I can share? Ja.
Oh, wacht, hier staat hij niet goed.
Ja, nu horen ze het niet.
Great, thank you.
Yes, I'm able to hear something.
Ja.
Dus dat moet werken. I think it should work now.
Yes.
Yes, I can hear some sound.
I can't see it yet. I cannot see your screen yet.
No, one moment. We're working on that.
Perfect.
Yeah.
And now we have more attendees, so that's perfect. Welcome everyone to our webinar co-organized with NGI DAPC. In a few seconds, I will just make a short introduction before giving the floor to our experts from DPO Consultancy, are Philip and Dunya, that you can see here. Indeed, so they will give us today the webinar on data privacy, a practical approach, as you can see, for the concepts and principles of GDPR. So Dunya Skelly and Philip Martens from DPO Consultancy are here with me. But before, just 2 minutes of very short introduction on the next slide for attendees who joined us and who are outside of the next generation internet world. So NGI Tetra, I'm Adele, I'm from NGI Tetra, and Tetra is basically a business accelerator that helps projects who received funding through next generation internet open call to enter the market via access to training, coaching, mentoring, and networking. And today the webinar is co-organized with NGI DAPC and with Sarah Matteo. And NGI DAPC, so it's a data portability and services incubator, as you can see it here. And they help innovators who develop human-centric solutions in the data portability field through access to top infrastructure, training, coaching, mentoring, networking, and visibility. So very short introduction, so you can have an overview for those who are outside the next generation internet field, as I said. And now I would like to give the floor to our experts from DPO Consultancy based in the Netherlands, Dunya Skelly and Philip Martens.
Thank you, Adele. And welcome also everyone. Sorry for the difficult or technical difficulties just now. Thank you for attending also our webinar regarding data privacy, a practical approach for the concepts and principles of the GDPR. Today, we would like to explain you more about how to practically implement the GDPR in your organization, big or small. The basic activities eventually remain the same. It might be good to know that we have received a couple of expectations and questions yesterday from Adele, and we will try to address these during our story, and feel free to ask questions by sending a message during the webinar or thereafter in the Q&A section in Zoom. We understand from Adele that most participants today have at least a basic knowledge on the GDPR and are mostly interested in best practices and our experiences. However, if you do need more explanation theory-wise, do not feel bothered to ask questions. But before we dive deeper into the GDPR and its implementation, we would like to introduce ourselves. My name is Dunja Scully, and I've been working for a DPO consultancy since 2019 as a data privacy consultant in several roles, such as privacy officer, DPO, and privacy support for many clients in different industries. My background is legal, and I've studied law and technology at Tilburg University, in which privacy was a substantial part of the master's program.
Well, thank you, Dunja. So my name is Philippe. I've been working roughly 1 year now at DPO consultancy as a data protection professional. Similar like Dunja, I've been working as a DPO privacy officers at various organizations, helping them to maneuver around the GDPR pitfalls, so to speak. Organizations that are in life sciences, automotive industry, or fintech. And so far it's been a very interesting field, and I like the career choice.
Oh, that's great.
Yeah.
Please feel free to send any remaining privacy-related questions to this email address also on the slide, as you see, info@dpoconsultancy.nl. That's good to know. Well, today we will first give you a short introduction also of our company that we work for, DPO Consultancy. The second topic will include GDPR principles, since they provide the foundation for every privacy management activity within organizations. In the third topic, we will further explain how you can manage your privacy management activities, meaning that you will learn more about implementing the GDPR. And we will end this webinar with a Q&A session. What is also good to know is that Adele will share the slides with you after this webinar. But first, a short introduction of DPO Consultancy. So DPO Consultancy is, like the name says, a consultancy company that is a one-stop shop with a 100% focus on data privacy. For us, being a consultant means that you are part of a customer's team from the moment a problem arises to finding and implementing a solution. The solution is including what we call the privacy journey, which entails all the needed privacy management activities to remain compliant to the relevant laws and regulations. We have a very broad national and international customer network, varying from startups to multinationals. And our customer network includes also a variety of industries, ranging from companies in the life sciences, government institutions, automotive industry, or fintech, like Philip just said. And our work in privacy and working with the GDPR means that our objective is to assure that the GDPR principles are at all times respected within organizations' activities. Like I just mentioned, these principles form the foundation of the GDPR. Now, these are the 7 principles listed in Article 5, so to say, in the GDPR. Personal data shall at first be always lawful, fair, and in a transparent manner in relation to the data subject, who is the individual whose personal data is processed. An example of this is providing a clear privacy statement on your website to explain what personal data the organization is processing in a clear and simple language. The second one, purpose limitation. Personal data should be collected for a specified, explicit, and legitimate purpose, and not further processed in a manner that is incompatible with that purpose. This means that if you process personal data of a customer for the purpose of delivering a good or service, for example, this may not be automatically be used for marketing purposes, such as sending promotional emails. The third one is data minimization. Personal data should also be adequate, relevant, and limited to what is necessary in relation to the purposes for which they are processed. For example, if you need to sell a license to use a software tool for which you need an email and name, you do not need to have the individual's address or phone number to achieve that exact purpose, namely activating a license to use the tool. You should limit the personal data that is necessary to the bare minimum. The fourth one is accuracy. Personal data should be accurate and, where necessary, kept up to date. Every reasonable step must be taken to ensure that if personal data are inaccurate, the data is erased or rectified without delay. This means that as a data controller, you should assure that the data subject can easily rectify or erase data on request. This is often possible through a customer portal online, for example, in which they can manage their own account details. The fifth one is storage limitation. You should keep personal data in a form which permits identification of data subjects for no longer than is necessary for the purposes for which the personal data are processed. This means that data should be kept only for as long as it is necessary, but it's good to comprehend that specific legislation might obligate you to keep data for a certain period. For example, in the Netherlands, many tax-related data should be retained for 7 years based on national Dutch legislation. The sixth principle is integrity and confidentiality. This means that personal data should be processed in a manner that ensures sufficient security of the personal data using appropriate technical and organizational measures. This includes the protection against unauthorized or unlawful processing and against accidental loss, destruction, or damage. And when this is not adhered to, this might lead to a data breach, which we all try to avoid, of course. The seventh principle is accountability. The controller shall always be responsible for and be able to demonstrate compliance with the above-mentioned principles. Since the controller is accountable, you should always document your compliance in everything you do regarding personal data. So now that you know what the principles of the GDPR entail in short, we can now dive deeper into how to exactly implement the GDPR in your organization. As discussed earlier, the privacy management activities model, also the PMA model, is a great way to keep track on the needed privacy management activities. The PMA model serves as an example of a high-over governance structure to help you implement and comply with the GDPR's concepts and principles. As you see here, there are 10 different activities that have several different controls that fall under these specific activities. The model can be divided in scheduled activities that you see on the left and continuous event-driven activities that you see on the right. Scheduled activities are activities that should always be scheduled on a yearly basis, which are the activities on the left. And the continuous and event-driven activities are dependent on a particular situation. One can think of a new processor that you want to conclude a data processing agreement with. The specific controls that fall under each activity will assist you in acting and remaining GDPR compliant, since such an implementation should always suit your organization. It greatly depends on the size and/or budget of your organization. For example, if you are a startup company, one can think of combining several policies in one overarching document, and you can keep it relatively short, while bigger organizations often deal with more complex business processes that result in extensive policies. Both can be GDPR compliant because it greatly depends on the particular situation within the organization. Let's start with the first activity. In this activity, data handling practices are assessed. It is an important first step for organizations because this will provide the insight in where the organization stands when it comes to GDPR compliance. A great way to achieve this insight is by performing a self-assessment by a third party or an audit. When we at DPO Consultancy start with the privacy journey at a new customer, we always recommend to let us perform an assessment on the operational practices within organizations. We do this assessment on the basis of the principles and requirements of the GDPR. For example, we always assess data subject request procedures, which is for the operational procedure regarding requests that the organization receives from individuals that request access, deletion, objection, etc. We then assess how easy it is to get in touch with the DPO privacy department. How fast does the organization respond? Is it between the 30 required days according to the GDPR? And are requests being registered somewhere? The result is that you exactly learn in what areas the organization needs to undertake specific action to improve its GDPR compliance. Based on this assessment, you can set goals and objectives to work on GDPR implementation projects, such as creating or updating your record of processing activities, concluding DPAs with your processors, performing data protection impact assessments, etc.
Yes. Then the second part of the PMA model, which we always assess, is the governance structure. And within every organization, there should be a clear division of responsibilities when you are implementing the GDPR. With always in the back of your mind that the board or the management of the company is ultimately responsible for compliance with the GDPR. But how you're going to implement it, you can regulate it in several ways. It always also depends on the size, the complexity of your organization. So, for example, for a small startup, it might be appropriate that one person is going to be responsible for implementing the GDPR, whereas in bigger organizations with many departments, you may want to install a privacy team. For example, you put somebody from your marketing department, somebody from your HR department in a privacy team together, and each person is responsible for maintaining privacy compliance within their department. Depending on your organization, it may also be necessary to install a DPO. Now, a DPO is a little bit different than a privacy officer. Privacy officers usually more busy with implementing the day-to-day privacy activities, whereas a DPO is actually a legal position in the GDPR. And the DPO is actually responsible for supervision, monitoring compliance. So that's really a different position. And for some companies, it may even be mandatory to appoint a DPO. For example, if you're processing special categories of data, such as health data or data related to criminal convictions of data subjects. So depending on the type of data that you process, it may even be a mandatory obligation.
Well, then maintaining a record of processing activities. This activity focuses on the maintenance of your inventory of all the processing activities within the organization. Although a record of processing activities is not an obligation if you employ fewer than 250 persons, the GDPR does sum up exceptions in which you are required to maintain a record of processing activities, such as if you carry out processing activities that will result in a high risk to the rights and freedoms of individuals, if you're not processing personal data on an occasional but regular basis, or when you process special category of data, such as health or religion. For this reason, we always advise organizations to create and maintain a record of processing activities, since it is an efficient way of maintaining an overview of your processing activities, and additionally is a substantial part of essential elements to document GDPR compliance. In this overview, you see a couple of elements listed that we always advise you to include in the record. An example is retention terms, to always be clear on how long you store data. technical and organizational measures. So what exact measures are you applying to protect the personal data? But also, does the personal data leave the European Economic Area to a third country, for example, which is a cross-border data flow?
Yes, thank you. Then the fourth element is document management. Now, this is maybe not the most exciting part of GDPR implementation. However, it is the backbone of your GDPR compliance program. And as Dunja said, the record of processing activities, I personally say that is the fundamental backbone, where you really map out all your processing activities, the data you collect, etc., for what purposes. But besides that, there are other things that we always advise clients to do and get in order to be able to show that you're compliant. So what's important in GDPR is the accountability principle. And how are you going to show that you're accountable? Now, for that, you're going to inevitably need some form of documentation. Now, of course, your privacy statement is like sort of the banner on your website that tells you, that shows already something about how seriously you take privacy. But internally, you also want to have procedures on how you handle a data breach, for example. What happens? Who does what? What are our obligations? That is something you lay down in there. But also, how do you handle data subject requests when somebody asks for access or for deletion? Also, your risk management is very important when you contract with third parties. You may have to carry out a data protection impact assessment if you're going to engage other parties or vendors to process data on your behalf. And also, if you're going to send data outside of the European Economic Area, you're going to have to assess the impact of the transfer. So you're going to have to look at what jurisdiction am I going to send the data towards, and does that jurisdiction have a equivalent level of protection of personal data in their own legal framework compared to the GDPR that we have in Europe. Also, an important aspect, I would say, is IT security. It falls directly under the GDPR, meaning that every organization is responsible also for keeping the data confidential and secure. Now, the GDPR does not really give you, it does not provide you with a checklist saying you have to do this, this, and this measure. It is always dependent on the size, complexity of your organization and the data that you process. Also, if you're, for example, doing CCTV, having cameras around the buildings that you own or your offices, that is something that's also a GDPR issue that you need to look into.
Yes, and then the fifth one, this activity focuses on providing ongoing training and awareness to promote compliance with the data privacy policy you have and to mitigate operational risks. This is very important, but doesn't always receive the much deserved attention. Nowadays, we still experience that most data breaches involve human error. That is why it's very important for individuals within organizations to fully understand what is expected of them and how they should act appropriately in their daily work. That is why it's recommended to maintain a core training program. And educating employees can be done in several forms, such as organizing workshops, e-learnings, etc. Whatever suits your organization best. You should also keep in mind that to conduct a regular refresher training to reflect new developments. In our experience at customers, this is also a great way to refresh the basic GDPR knowledge within the organization. One should also think of conducting training for newly appointed employees, so they are immediately up to date on what is expected of them within the organization. And the last point is that you should always consider maintaining a second-level training program reflecting job-specific content by position or job responsibilities. In several job positions, it can differ a lot in how much they need to know about personal data and the GDPR. For example, a marketing manager needs to have more in-depth knowledge on profiling and consent than an employee in a facility department. And then managing third-party risk. Well, this activity includes the maintenance of contracts and agreements with third parties and affiliates consistent with the data privacy policy and legal requirements. Maintaining data privacy requirements for vendors is a necessary and efficient way to assess what elements your organization finds important in the cooperation with vendors. Elements such as that the vendor provides regular training to its employees to also avoid data breaches, of course, or that the vendor secures data with certain technical measures. It can be anything. It's also very much needed to maintain procedures to execute contracts or agreements with all processors, since you are obligated as a controller to always conclude a data processing agreement with every processor. Conducting due diligence around the data privacy and security posture of potential vendors' processors. This is a very important element of choosing with which processor you want to get involved. In a proper due diligence, you assess multiple components in your data privacy requirements, as earlier mentioned, but you also do research regarding their reputation. Did the processor, for example, experience multiple data breaches in a short amount of time? That can be a big red flag, since their privacy management activities might not be in order. Another control is to maintain internal guidelines for contract templates that establish data privacy obligations in all contracts and agreements, such as data processing agreements and standard contractual clauses, and this might save you a lot of time and effort when negotiating contracts with the vendor. Also, the review of long-term contracts for new or evolving data protection risks is necessary, since situations, processing activities might have changed. And last, to maintain a vendor data privacy risk assessment process, for example, you might encounter a vendor that is a processor and transfers data internationally, also outside of the European Economic Area, to a third country under the GDPR. In that case, you need to conclude an SCC with this processor, but that also means you have to perform a TIA, which is a transfer impact assessment. This might have a great impact on your risk assessment. And since most companies transfer data internationally on the basis of SCCs, the standard contractual clauses, we think it's also very useful to learn more, for you to learn more about the mandatory TIAs. A TIA is a mandatory tool that enables an organization to assess the privacy risks involved when sending data internationally outside of the EEA, the European Economic Area. At the moment, the TIA is form-free, although the European Data Protection Board provided draft guidelines on how to conduct a TIA and what supplementary measures can be implemented to mitigate risks. And if the supervisory authority contacts either the importer or exporter to see the TIA that has been conducted for the transfer, the TIA must be provided. It is in line with, again, the accountability principle of the GDPR that requires organizations to document their GDPR compliance. When a TIA is performed, one should take the following step. Step 1 means that you retrieve the needed basic information to fully understand the data lifecycle from A to Z in the processing activity. This is also the basic information you include in your record of processing activity, which means that if you have that in order, it's less work for you to perform the TIA. Step 2, when applicable, also assess if there are any sub-processors involved. And step 3, this is the largest and, in our experience, hardest part, because you need to look into several laws and regulations in the particular country, also industry-specific, state-specific, and assess how the GDPR principles and concepts are respected in that particular country. That said, if you do keep track on the changes of laws, and if you have already done, of course, an assessment in a country, you can, of course, reuse that information. If you want to learn more about the TIAs themselves, we recently provided a webinar on conducting TIAs at DPO Consultancy, which is available on our website.
Yeah, the next part is data breach management. Now, this is one of the more, I would say, important ones. In practice, data breaches, they are very hard to be avoided. And of course, not every data breach is the same and not as serious. But at least you should be aware of the minimum requirements. And that is, as soon as you discover a data breach, there is a legal obligation for you to notify the supervisory authority within 72 hours upon discovery. And depending on the severity of the breach, you may also have to notify data subjects themselves without undue delay. So that's an important difference. There's a 72 hours for the supervisory authority. However, for data subjects, there's no specific time requirement. The law basically says just as fast as possible. Well, in our day-to-day practice, we've encountered several types of data breaches. One that I encountered myself, the client was, for example, this particular client experienced several hacks of mailboxes of employees. And of course, mailboxes are, well, if not properly cleaned up regularly, they can contain an enormous amount of information, confidential information, but also personal data. So that is, in that case, it's quite serious, because there may be correspondence in there with clients of yours. And if a malicious actor obtains access to client data, then also your clients may be at risk of being attacked through your company, which of course can be quite a reputational risk as well for your company if something goes wrong. Other examples of data breach are also that in some cases you may have certain processors, so other companies that process data on your behalf, that experience a data breach. However, you will still be responsible for that data. For example, if you engage a data management company that will keep the data for you, or process the salaries of your employees, if those companies experience data breach whereby the data of your own employees is leaked, then you are still responsible for notifying the supervisory authority and notifying your employees.
And then the eighth, monitor operational practices. Well, under this activity, the aim is to monitor organizational practices to identify new processes or material changes to existing processes, and to ensure that the implementation of the privacy by design principles is fully done. A privacy by design framework is recommended for all systems and product development. In the next slide, we will further explain the privacy by design principles themselves. A successful implementation of privacy by design may result in a cost-efficient business process because of the fact that privacy is involved in a very early stage of the design phase of a system or product development, compared to a costly adjustment of products and systems in a later stage. Furthermore, monitoring new processes or material changes to existing processes might result in a need to perform a DPIA, a data protection impact assessment. It is therefore recommended to maintain clear guidelines, templates, and procedures for conducting DPIAs. In such a procedure, a sign-off by management is important because management is in the end the accountable controller. But the involvement of the privacy office is also recommended, if there is any, of course. When you are a bigger organization, it might also be very valuable to include the product lifecycle process to track privacy impacts of changes to existing programs, systems, or processes. Since we experience in our work with customers that DPIAs remain a difficult topic to comprehend, we will also provide more in-depth information about this GDPR requirement. But first, the privacy by design principles. Privacy by design are abstract principles that are not a clear-cut piece of theory that you can implement in practice. It is still very much a gray area, and there is room for interpretation, which is nice on the one hand, but also very difficult on the other hand. Privacy by design originated in the early 90s and is an engineering and strategic management approach that allows you to selectively and sustainably minimize information systems privacy risks through technical and organizational controls. Dr. Anne Cavoukian developed this modern conceptualization of privacy by design because she believes that privacy should be embedded into information technologies, business practices, and network infrastructures as a core functionality. So what are these principles exactly? The first is proactive, not reactive. For example, if you want to achieve privacy commitment within an organization, continuous improvement is necessary, and you should proactively work on remaining the level of commitment within the organization. You often see nowadays that companies, organizations are still reactive, which can definitely be improved. The second one is privacy as the default setting. For example, not checking the box automatically for marketing communications if a customer registers on your website is a great example of privacy by default. The third one is privacy embedded into design. For example, if you set up your IT infrastructure in a way that provides you the possibility to easily locate and therefore retrieve personal data in case you receive a data subject request. Step 4, full functionality. Full functionality should not be impaired, and to the greatest extent possible, all requirements should be optimized. Basically, you can combine different objectives like achieving privacy compliance, achieving revenue, and even grow with your company. You're not sacrificing one for the other. Step 5, end-to-end security. Meaning that from input of the data by a customer, for example, to the output with a sub-processor, the data should be encrypted along the way. The sixth one is visibility and transparency, which is crucial in establishing trust in your organization. And the seventh is respect for user privacy. This can be done, for example, by giving the data subject full control over his or her data in a customer portal, where he or she can make adjustments, delete their account, send data subject requests in an easy manner, etc. So now that we have discussed the privacy by design principles, we can now dive deeper into the other requirement, the DPIA. It is first important to understand when to perform a DPIA. Just like the TIA, the DPIA is a mandatory tool to assess privacy risks before the processing starts and to be able to mitigate these risks by taking appropriate mitigating measures that leave an acceptable low residual risk. Since modifications are made within processing activities over time, one should realize that DPIAs need to be updated on a regular basis. The frequency depends greatly on the size of your organization and the modifications made in the processing activity. If it is a substantial modification of the processing activity, one should update the DPIA as soon as possible. The GDPR provides 3 situations in which you should always perform a DPIA. One can think of profiling with the first one, use systematic and extensive evaluation of personal data aspects relating to natural persons, which is based on automated processing. The second one, if you process special category or criminal offense data on a large scale, and it's good to comprehend that the processing of special category of data are in principle prohibited under the GDPR and are only allowed on the exceptional grounds given in Article 9 of the GDPR. And the third one, systematically monitor publicly accessible places on a large scale. For example, you can think of CCTV usage in a publicly accessible place like a mall. But there are also specific guidelines provided by the European Data Protection Board. and by national data protection authorities. The identified high-risk situations mentioned by the European Data Protection Board are summed up on this slide. The rule here is that when you can indicate that at least 2 situations apply to your processing activity, you should always perform a DPIA. One example is the evaluation of your employees' work performance. This might not seem like a high-risk situation, but it covers at least situation 1 and situation 7. Situation 1 because you're evaluating and scoring your employees' work performance, and 7 because a vulnerable data subject is an individual that finds herself in a relationship with an imbalance in power. The employee is always considered to have less power than the employer, which why they are a vulnerable data subject. If you would like to learn more on how to conduct a DPIA exactly, we also recently done a webinar on this topic. You can also watch this on our website.
Yeah, then the next point is the complaints and data subject request management. Now, data subjects, meaning you, me, everybody of whose personal data is processed by another organization, has certain rights in the GDPR. That means that if a company processes my personal data, I can ask them at all times, and they have to comply for access to the data. They have to show me what data they process of me. That means that if you're an organization, you always have to comply with an access request. In some cases, they may also ask to rectify their data. Simple example: if a customer of yours has moved to a different location, you may want to update their address because it's no longer accurate. Also, an important privacy right for data subjects is the right to erasure. Now, under certain circumstances, I, as a data subject, have the right to ask another company that processes my data to erase that data. Now, normally you have to comply and you have to erase the data unless there's a specific law that tells you you really have to retain the data for a longer period. Now, an example in Dutch law is, for example, if you are an employee at a company, you have to give a copy of your ID card to your employer, and your employer is, based on tax law, is legally required to retain that copy of your ID card for at least 5 years until after you have left the company. So let's say you leave the company and you want your employer to delete a copy of your ID card immediately after you've left. Your employer cannot comply with such a request because there's still a legal retention term. And of course, when you're a company, you also, or a data controller, you have to maintain your procedures on how you handle such requests. You have to be prepared and know what to do when you receive an access request and an erasure request. For example, you always have to respond to requests within 30 days. Now, in practice, when do we see data subjects invoking their rights like this? It's usually when something goes wrong within an organization. So let's say there's been a data breach and the data subject's been informed that their data has been leaked to another party or to another actor. Then they will often ask either for access to see exactly what has been breached, or they will even request erasure, simply because the trust has been broken and they want to have their data deleted. The final part of our PMA model, the final point, is track external developments, which means that within your compliance program, it's important to track what legislative developments there have been recently in terms of privacy. Now, privacy is still a legal domain that is evolving very rapidly. New legal opinions and new case law regularly appears, giving new insights. A recent example of that is the Austrian supervisory authority that has said that the use of Google Analytics by companies in Austria, by a company in Austria, was violating the GDPR simply because Google Analytics was sending data to the USA, and that data was not secured adequately in a way that would prevent the US government from accessing data of European data subjects. So that is an example also of a judgment by supervisory authority, where they say, okay, it's not allowed to do this anymore, but at the same time, they have not really given us the solution yet. And that makes this judgment kind of problematic. So they say European companies should not use Google Analytics. It violates GDPR. But at the same time, they really haven't said how you can then use Google Analytics in a secure way. So what is left now for organizations to do is verify, of course, do we use Google Analytics? Is it really necessary for us? And if yes, can we maybe use an alternative to Google Analytics? For example, that a company or a service that does the same as Google Analytics, but does not transfer the data to the US. But as of now, this is still an example of a development within privacy law that is still unclear, but could have huge ramifications for companies and the use of certain services.
Yeah, and if I can add, companies should always prepare for multiple scenarios, of course. So in the long run, I really hope that Google will be more transparent and will compromise in terms of implementing more secure measures than they do right now. But this is a great way for organizations to already get started and research alternatives, for sure.
Yeah, then final quote to end the webinar. It's a bit of a lengthy one, but what basically comes down to the way I interpret it is that the GDPR is, of course, a European law. However, the data economy is that we live in is completely globalized, meaning that data is flowing all over the world. My data may be in countries that I don't even know of. And of course, what the problem with having a global data economy but fragmentized legal jurisdictions is that there are differences among jurisdictions on the respect and on the protection of personal data. And here in Europe, we regard ourselves as having a very high level of protection of personal data. And but if you then we compare ourselves to other countries outside Europe, we might say, okay, this level of protection is not really equivalent to our own. So what you then, at that moment, of course, you have to take extra measures. The law is still quite vague on, as I just explained, for example, with Google Analytics, on how data transfers then should be happen in a compliant manner. There is still a lot of clarity to be given by regulators. But I think what it comes down to now is that we have to, as an organization, you have to strike a balance between the free flow of data globally that is necessary to do your business, and the protection at the same time of that personal data and respect of privacy. So doing everything in your own power that you can do to make sure that the data transfer that you do carry out are as secure as possible. And I will leave it at that for now.
Yes, thank you. So this was our webinar, and we are also ready for some questions. I saw, maybe you can read them.
No, there's so far I haven't read.
Okay, I thought there were some.
I haven't read the question so far. Okay, there's one.
Okay.
Should I read it for
you?
Yeah. Do you think that the current GDPR dictated privacy protection landscape is sustainable going forward? Users are still not reading privacy policies, so they in fact give uninformed consent. Do you see this changing in any way? And if you could install an application or say privacy is a digital, is it a digital legal assistant? Okay, so I think what I get from this question is that users may not still, not be informed properly and just consent without really knowing what they're consenting to. And I think in practice that is probably true. In terms of informing data subjects, there's still a lot of companies are not quite transparent where exactly they are sending data and what exactly are the risks for the data subject. In terms of sending data abroad to jurisdictions that they may not know, or that may actually be inadequate.
Yeah, you often read in privacy statements that we might send your data to third countries, which is really problematic. I do believe that the GDPR is sustainable, but we definitely, of course, need to make adjustments to make it more practical, more efficient, because, just like you say, sometimes you visit certain websites where you can say accept all, but you don't have a reject all button yet. So I guess that's still in development and it never stops.
No.
But I think it is sustainable, and we also often see that global operating companies also take the GDPR as a standard for their global activities, which is a very good thing, I would say.
Yeah. Another question then. We provide end-to-end encryption. Many customers from Germany ask us to provide a data processing agreement. Can you confirm this is legally required? We cannot see any unencrypted data as administrators, and also, do you have ideas why we only get these requests from Germany and not other countries? Now, data processing agreement is always required if one company engages another company to process data on its behalf. So if your client is engaging you to process data, even though that is encrypted, I assume it can still be decrypted.
Yeah.
So it's still personal data. So that does not mean that the GDPR does not apply. So in that case, yes, a data processing agreement would actually be a mandatory requirement. Now, the question as to why it's only from Germany, you get these kind of, I am not sure, because...
Well, I think it's because Germany and also Poland, in my experience, are countries in which the GDPR is very strictly applied. The basis of the GDPR is also found on German law. So I think the Germans are very strict in their compliance with the GDPR, and that's why you receive these requests from Germans. Yeah.
Yeah, that could very well be the case. Yeah. Any other questions? There's another one. Do the leading technology companies comply with the GDPR regulations efficiently? We use Google Suite, for example, G Suite. Is it possible that companies can share our data outside the EU? This is the most important concern among our EU project partners. How can we be sure that we are in line with the regulations while using very common cloud solutions like Google Workspace, Azure?
Yeah, the problem with Google is transparency. I also encounter Google with many customers I support, and you don't get that clarity, you don't get that confirmation where the data is flowing. So the cloud services that provide you more control and in which you're in more control of your own data are more GDPR compliant, so to say, of course, with all the other requirements in place, all the technical and organizational measures. But that is, I think, the biggest problem with Google services. I don't know if you want to add something, but I hope that's sufficient.
AWS, Amazon Web Services, I think. Can you scroll down?
Exactly.
Yeah. Any other questions? This is specifically for Google. Well, actually, all tech companies encounter these problems. I think also Amazon, for example, AWS, is a global operating company. And the real question are whether these companies are compliant strictly to the law comes down to are they taking sufficient measures that prohibit the US government from accessing the data that they have on European data subjects. And so far, the practice has shown, and also the case law has shown, that is not the case. So the US government can still access that data in many cases, and it is not. But the problem is that there's no solution yet as how that can be stopped from happening. So as long as that is the case, often what we've seen now is that these companies, Google, Facebook, Amazon, strictly to the letter of the law and strictly to the letter of the GDPR, they are not compliant. And this is, as of now, this is an issue that cannot be that is not solved yet.
No.
And there will need to be more legislative developments, more legislative clarity as to how what then should be done by companies in order to be compliant using these the services of Google, Amazon, and Facebook.
Yeah.
I hope that gives you some clarity. We would like to offer tools for data mapping of data silos. Is it possible to collect the mapping added to the tools by customers for science purposes? I'm not sure exactly what you mean, but within the GDPR, there is a legal ground that you can use for collecting data, and that is for scientific purposes. But I don't think I have enough information really to give a good answer on this question.
Maybe one last question, or because we are approaching slowly the end of the webinar. So if you still have questions, please shoot now. This is the moment. That was the last question. The data mapping of data silos.
Yeah.
Perfect. Great. So thank you. Thank you so much, Dunia and Philip, for your very insightful webinar. I will definitely share with the participants your presentation, also your website, because you mentioned some materials that are available on your website.
Yeah.
And so that is great. I will definitely share it with all the attendees. And I would also like to mention that would you like to continue the GDPR journey? We have still 2 upcoming webinars, one in February and one in March, given by IPIL, the Institute of Intellectual Property in Luxembourg, from NGI Tetra, on the 23rd of February, and on the 9th of March. I will also send you more information, and you can find it on our website, NGI Tetra. I will share it with you as well. So thank you very much to everyone, to all the attendees for being with us today. And again, Dunia and Philip. And let's end this webinar, and I send you all the information today.
Okay.
Yeah, it was a pleasure.
It was a pleasure.
Thank you.
Thank you all for attending, and have a nice day.
Yeah.
You too. Have a nice day, everyone.
Okay. Bye.
Goodbye.
Bye.